Great. Thanks, Kelly, and thanks for setting this up. Hello, everyone. Again, I know some of you, I see some of your names. My name is Sam Brooks. I'm an attorney at Community Legal Services. And I'm really excited that you guys are all here. I wanted to do this webinar because I'm not sure how many people do these types of hearings around the state. So part of it is to just give a brief overview of what to do, but also to establish connections and let you know that I'm here. And you ever have any questions, my contact information is at the end of the presentation. This is an issue that's near and dear to me. So part of this is selfish as well, just to establish contacts around the state. That being said, I want to jump right into it. There's a lot to cover. I'm dealing specifically today with involuntary discharges outside of the Medicare context. Many of you may see this, people receiving notices of non-coverage for Medicare, and oftentimes facilities treat these as discharge notices. But I'm not going to go into today about how you appeal a Medicare notice. This is purely about involuntary discharges based on federal and state laws once a notice has been issued. So the reason I slimmed it down was it's just a lot of information. I can give another training on that at another time. So today's goals are really understanding the rights and defenses around nursing home discharges under both state and federal law, strategies for advocacy with the nursing home, fair hearing strategies, and also establishing, a network, and we can all hopefully, you could all use me as a resource or each other if you get into this type of practice. So involuntary discharge. Just to go back a little to the Medicare context, oftentimes what happens is for short-term stays, Medicare pays, and the facility often will issue what they call a Medicare Notice of Non-Coverage, or a NOC. And that's a notice that says, we believe that your coverage will stop on this day. You certainly have appeal rights for that. However, that's not a discharge notice. Facilities use these Medicare notices as discharge notices. They use them to bully residents to leave. But by law, it's not a discharge notice. If the person is going to be involuntarily discharged, a separate notice needs to be issued. And that's what we're dealing with today. We're dealing with when someone is being removed and they don't want to be. So most of this is federal law, and we'll get right into it. You can only discharge for 6 statutorily permitted reasons. And we'll go through each one. 1, necessary for residents' welfare and facility cannot meet residents' needs. This is a very common one. It often comes up with people who are severely cognitively impaired, and the facility just doesn't want to make the commitment to provide the appropriate care for that person. So they'll say they can't meet the needs. We don't have a dementia ward or a dementia wing. And we're going to go through each of these in turn. Residents' health is sufficiently improved and no longer needs nursing facility level of care. Pretty self-explanatory. The safety of individuals in the facility is endangered by the resident. This is a very common one. The health of the individuals in the facilities would otherwise be endangered. And the resident has failed to pay after reasonable and appropriate notice. And lastly, the facility ceases to operate. Certainly, we're not as concerned about number 6. However, there's still discharge and appeal rights, which is important. But number 6, obviously, we're not going to try to keep them in a facility where that doesn't exist anymore. So we're going to move through each of these and talk about some common scenarios. Written notice is required for every involuntary discharge. And I should say up front, if you're a nursing home operating in in Pennsylvania, these regulations apply to you. I'm not sure if there's any nursing homes that don't take Medicare or Medicaid. And if they take any Medicare or Medicaid dollars, all these regulations apply. I'm sure there's maybe some private facilities, but those aren't the type of people that we're dealing with. Those aren't our clients. So these are going to apply to any facility that take Medicare and Medicaid. So there has to be written notice when the facility intends an involuntary transfer or discharge. Even if the resident has been there for less than 30 days, notice must still be provided. So again, in that context of the Medicare notice, just because they estimate Medicare is going to stop paying in a few days doesn't mean that they can just kick you out. They have to issue another notice. But practically that rarely happens because they scare the bejesus out of the resident. And the resident either leaves or doesn't pursue appeal rights. Facility should provide notice 30 days in advance of proposed transfer or discharge, or as soon as practical if certain exceptions apply. If the resident has been in the facility for more than 30 days, they're required to a 30-day notice. Under 30 days, they're not required a 30-day notice. So that's things to know. For long-term folks who have been in the facility, that notice has to be issued at least 30 days prior to the date of discharge. Under 30 days, it has to be as soon as practical, unless certain exceptions apply. Residents' welfare requires a move to another facility, and a more immediate transfer or discharge is necessitated by the resident's urgent medical needs. So they're saying, again, it's going to fall into that, maybe that first discharge category. We can't meet their needs here. They need to go somewhere else. Transfer discharge based on allegations that the resident is a danger to safety of health or others. And a resident no longer needs the services. And as I said before, resident has not resided in the facility for 30 days. All of these can be found at the citation there in the Code of Federal Regulations on 42483.15. So if the resident's been there for over 30 days, it's going to be very hard to convince a judge or anyone else that less than a 30-day notice is allowed. There are exceptions, but practically, if that person has been there for 30 days, there has to be a 30-day notice. And in my experience, the courts will, excuse me, the administrative courts will enforce that. Again, questions, I'm looking at the group chat box. If you have any questions, if I'm going too fast or this is too confusing, just let me know in the box. It's awkward not being able to see anyone and just talking into space. So one of the most easiest ways to deal with these is to make sure that the notice is 30 days. And I just had someone who had I was helping someone the other day whose client got a notice that was 29 days prior to the date of discharge. And I would say that that notice needs to be rescinded and reissued because it's not 30 days. What are not exceptions? When the transfer or discharge is based on allegations of non-payment. This is a very common scenario where the facility says we're not getting paid. Either the person is not financially eligible for Medicaid, or they're having a hard time getting the Medicaid grant approved. This is not a sufficient reason. Unless the resident is being so belligerent and unhelpful, it's not appropriate to discharge someone, one, for failure to pay, or two, earlier than the 30 days. And we'll go into that later on. So there's a pretty high bar in these cases where the allegation is non-payment. Facility needs to show that somehow that resident hasn't been helping with the Medicaid grant. Notice contents, and this is what's important. You can often win these cases on the notices because facilities can't write an appropriate or correct notice. And really, I'm not sure how many people do these hearings, so I'm not sure how often they're caught. But these are very important parts right here in advocacy. It has to, of course, include the reason for the transfer or the discharge, of course, the discharge date, where the person is going to be discharged to, the right to appeal, the name, address, phone number of the state long-term care ombudsman. Another good thing is that part of, there were some regulations passed within a couple of years. Now, whenever there's an involuntary discharge notice issued, it is sent to the long-term care ombudsman. So oftentimes they get involved. If the resident has a developmental disability or is mentally ill, they have to provide the number for those types of individuals suffering from those types of disabilities. The notice must be given to the resident, and if known, an immediate family member, a resident, or legal representative. And it must be written in a language that the resident or resident's rep will understand. So obviously, if the resident is not English speaking, it has to be in the language that the resident understands, and it also has to be in layman's terms and not in terms that average nursing home resident wouldn't understand. So oftentimes these are some improper justifications for transfer or discharge. Resident is disruptive or argumentative, resident does not follow facility policies, resident has injured staff members, refuses treatment, or the care is too burdensome and or expensive. These are often scenarios these are often reasons that they try to discharge individuals, and they cloak them in some of those initial 6 categories that say, hey, these are the only reasons you can discharge folks. And these aren't, and we'll go over how to show this later. These aren't appropriate reasons. These are folks who are severely impaired and severely disabled, and the facility has to make accommodations for their disabilities and their various problems. And in the next couple of slides, we'll talk about how to deal with that. The basis for transfer or discharge, it must be documented in the resident's clinical record, unless, of course, the facility is ceasing to operate. This documentation must be done by the resident's physician when it is because the resident is being discharged because the welfare requires a transfer or discharge, or based on allegations that the resident no longer needs facility services. So in those instances, the documentation in the resident's clinical record must be done by the resident's physician. If it is based on endangers the health or safety or others, then the documentation may be done by any physician. In all other instances, documentation may be done by facility staff. So as part of advocacy with these types of cases, you're going to ask for the nursing home records. And again, this is dotting I's and crossing T's, but if this documentation isn't made by the appropriate people, appropriate staff, that's one way to get the notice rescinded and dismissed. And part of that, at least I find with this, is if you put up a little resistance to these nursing homes, is they will give up. And they, you'd say, well, you got the notice rescinded. What does that do? But oftentimes, once that notice is rescinded, the nursing home has felt like, they've been caught, they're discharging for an inappropriate reason, or the notice is bad, and they won't try again. So sometimes that's the victory, just getting the notice rescinded and sending, you got shots across their bow that someone is watching and enforcing the law. So a safe and orderly discharge, and this is what's very important. I think this is another aspect, and this is where we win a lot of cases. So even if one of those 6 areas are met, it doesn't mean that you can discharge them anywhere. There must be a safe discharge, and that has to be a part of the notice, and it has to be a part of the discharge. So it's not that the facility just needs to show that one of those things are met, but even after one of those things are met, the facility has to show that there's appropriate place and appropriate care for that person who's being discharged. And it says right there in the Code of Federal Regulations, a facility must document sufficient preparation and orientation to ensure safe discharge. These are specific to involuntary discharge, but are also part of the general obligation of the nursing home to provide for discharge. Every nursing home resident needs a discharge plan. That's part of federal law. And that's whether you're being discharged or not. They have to have a discharge plan. For people who are involuntarily discharged, these are enhanced protections. So oftentimes, the discharge plan is done without any participation of the resident or the family, and that violates federal law under 42 CFR 483.21, as you see there. However, practically, courts or the hearing officers in these cases, which we'll talk about later, aren't going to stringently enforce that. I think this is an important one. I used to do this presentation based simply on federal law, but there's this nice nugget here in the Pennsylvania Code that says the facility is responsible to assure that appropriate arrangements are made for a safe and orderly transfer, and that the resident is transferred to an appropriate place that is capable of meeting the resident's needs. That's a really good, strong piece of regulation right there that can be used as a way to defend against these involuntary discharges. They're being discharged home, but there's no services there. They're being discharged, in some cases, we get these cases in Philadelphia, to homeless shelters and to other places that aren't safe for people who need nursing home level of care. So not only does federal law require appropriate and safe discharge, so does the Pennsylvania Code. So these are all tools we can use to appeal these notices. So filing an appeal. This is what it says in the rules. These rules are strangely governed by the nursing home discharge, involuntary discharge rules are governed by an appendix in the Pennsylvania Code that is arguably illegal, but we'll talk about that later. But this is what needs to be on the appeal if you're filing the appeal of an involuntary discharge. Intervention requested has to be right on top. The notice has to be included. And you have to be BHA, I'm pausing here out of frustration. Bureau of Hearings and Appeal say that they no longer accept faxed appeals. These are all governed by BHA in Harrisburg. That's what I think. At least they all, in Philadelphia and the surrounding counties, all of these hearings are done by BHA in Harrisburg. I don't know if it's different in other parts of the state. If anyone has experience with that, I'd like to hear it. But BHA is adamant now that they won't accept faxed appeals. I still fax them anyway because they're time sensitive, and there's really no support for them to say that they can't, we can't send it by fax. But I also mail the original. File right away, as long as it's, it can be before the proposed transfer discharge date, the day before. In the appeal, in the notice, excuse me, hold on, let's go. If there's no written notice, you can still file the appeal. So if they're saying, hey, Mr. Smith, we're discharging you tomorrow, but they issue no notice, and this does happen often, you can still file an appeal the same way. You write the same letter, except you add that the facility has failed to issue any written notice, and that the BHA sustain your appeal and preclude any discharge until a proper notice is issued. And oftentimes, again, once they're caught like this, they will give up. They won't actually come back and issue a notice. So it's very important to know that just because the notice wasn't filed, if there's some oral indication was made that the person is going to be forced to leave in the upcoming days, you can still file an appeal. So this is what you do if notice is defective. If notice doesn't contain the statutory required elements, move for the notice to be quashed. So most likely successful, where we're successful, is notice failed to state discharge location at all. Some facilities will do this. They'll issue a notice, but they won't even say where the person's going. It failed to indicate the date of transfer discharge and failed to indicate the reason. So if those are issues in the notice, you want to put that in your appeal letter to the Bureau of Hearing and Appeal. You want to say that this notice is defective, it doesn't meet the statutory requirements, and you want the notice to be rescinded or quashed. How you do this is somewhat time sensitive. If you might not put it in the notice, or you might not file it as soon as possible if it can buy you more time, if that makes sense. If you're asking them to rescind the notice, you want to have as much time for your client as possible in the facility before you ask that to be rescinded. However, practically how that works, we'll talk about in a second when we're talking about these hearings. I'm going to move on to hearings. I'm moving at a very brisk pace here, probably faster than I need to be.
Sam,
but maybe, yeah.
I'm sorry. If I could just interrupt, I need to launch the first poll for CLE credit at this time. It'll be up for 2 minutes for everyone, so please respond, and you can continue. Thank you.
Thank you. All right, so I'm going to move on to how these hearings are conducted, and this is where it gets even very bizarre. But if there's questions, again, just put them in the box, and also we'll be able to talk at another time too if you have, you'll have my contact information. So moving on, hold on one second. So the hearing, what will happen is that once your appeal is filed, the hearing will be scheduled. And again, in our experience, these hearings are all conducted out of Harrisburg. So practically, they're all going to be telephone hearings. However, we will talk about some strategies around this. There's one ALJ that does all the hearings, I believe, for the southeastern Pennsylvania. I'm not sure if it's crew across the state. It's ALJ named Lois Lara. And she is problematic in some ways, and we'll talk about that. So we've developed a strategy to try to ask for hearings in person, to get it out of the Harrisburg office and maybe get it to a more friendly and more reasonable ALJ. And I'll talk about that more as we go on. The hearing, we'll talk about residents' rights prior to the hearing, in person versus telephone, evidence, witnesses, and the importance of medical testimony. So just like in any other hearing, you have a right to examine files, documents, and records to be used at a hearing, subject to a reasonable time or place. So once your appeal is filed, I think at the same time, you're also sending a letter to the nursing home asking them for a copy of the medical record and any other documents they plan to rely on at the hearing. You have a right to them prior to the hearing, and I would object to anything that you weren't allowed to be, that you didn't review prior to the hearing. You have a right to be represented by a person of choice, but you do not have a right to an attorney. And you do have a right to bring witnesses. You have the right to question and refute any testimony or evidence, including opportunity to confront and cross-examine adverse witnesses. So the same rights you have in any sort of fair hearing with a public benefit. And a right to continued Medicaid payment for care until hearing is held and decision is reached. So if you're on a Medicaid grant, your benefits continue. So again, getting back to this, in-person hearings are difficult because we're dealing with individuals who are disabled in a nursing home. However, talking about your severely disabled client over the phone, the judge does not get to see him or her, and it's much more easier for the judge to dehumanize or ignore nursing home residents' problems if they can't see them. Additionally, the ALJ that conducts these hearings conducts them with an iron fist, does not take into consideration that the resident may be very impaired, isolated, not understanding of the process, but they're very strict. She won't allow hearsay, she won't allow relaxed as general hearings. So our strategy is going to be to try to ask for hearing in person and try to get them out of for this. I imagine they would balk at your request, but it's that you have an in-person. And that's what this language is here. So the rights of appellant. Appellant has the right to appear in person at the hearing and may represent himself. Hearings will be held at the Regional Office of Hearings and Appeals. So there's no support really in the Kelly, do you have your phone on, not on mute? I'm getting feedback.
Let me try muting it.
Is that any better, Deb? I know Steve said it was going in and out. I'm going to continue as if you can hear me, but please put into the group chat if you're having a hard time hearing me or it's cutting in and out. Okay, so this slide here is one I added recently after some bad experiences, again, we've been having with these ALJs. So if it's possible, I would always suggest having an in-person hearing. One, build sympathy for your client. I had a hearing recently where my client could barely walk, and the facility was saying, oh, the client can dress himself, he can feed himself, and anyone looking at him could tell that's not true. He couldn't feed himself, he was incontinent, he couldn't dress himself, but the judge didn't see the person and couldn't see them. And it was very easy for the judge to say, oh, to take the word of the facility when any reasonable person looking at my client would see that they were not being truthful. So it serves two purposes of in-person hearing. One, it helps build sympathy for your client, and two, it gets it away from bad ALJs. I'm not sure that you'll get a great ALJ, but it's better to take a roll of the dice than to deal with the one that we've been dealing with. Obviously, telephone hearings are going to have to be an option for some folks that are sick and can't get out of the facility, or even for, even for if you're far from a hearing office, it just won't be practical. Again, you're losing the luxury, or not the luxury, but you're losing the ability to have your client humanized because you can see them. What I might suggest in situations like this is if your client has, if there's some reason for pictures, for evidence, that be submitted so the judge has pictures of your client to see. It's amazing. It's really easy to treat someone like garbage when you don't see them. And unfortunately, I think that happens all too often. So again, this is where it gets very bizarre and something that we really need to pay attention to, and what makes these hearings very hard. As I said before, ALJ is now really refusing to allow hearsay and applying stricter hearing rules, and that's hearing with one N, not two N's. Again, in a recent hearing, the ALJ, very strict about hearsay, very strict about procedural, not very relaxed hearing. And this overwhelms a nursing home resident. I had a hard time doing the hearing because it was so bizarre. Imagine what it's like for a nursing home resident that's stuck in a bed. You want to have a copy of the nursing home file so you can submit documents to BHA that you intend to use to direct across. So you want to refute that. You want to have the file so you know what you're dealing with. This is in red. This is the most bizarre thing, and I think might be the only state in the United States that does this, but places the burden on the nursing home resident. So the burden at the hearing is on the nursing home resident to show that it is an improper involuntary discharge. For those of you who do these hearings, hearings that, welfare hearings, you're well aware that the burden is always on the state or the agency making that taking the negative action. However, about 20 years ago or 25 years ago, Pennsylvania issued these very specific rules regarding involuntary nursing home. Sorry, I'm reading questions and talking at the same time. Regarding involuntary nursing home discharges. And this is some advocacy we're doing on it. One, we think it's an unpromulgated regulation. It's a regulation that binds the Bureau of Hearing and Appeals, and it was never properly promulgated. Two, it's just so contrary to what is accepted both nationally and in the state. There's no other, state agency-run appeals where the burden is on the appellant. No, I'm liking to hear this. Yeah, so there's a comment here. I've had a few hearings in which the burden was on the home, but the last few have been on the resident. And I'm wondering if that was, I'm reading this question from, or the statement from Jennifer Costello, if that was with Lois Lara. I had one of these hearings and I was so shocked by it. I mean, my client was being discharged because he had assaulted someone in the facility. My client was severely impaired. He had dementia. He didn't know what he was doing, and someone had wandered into his room and got in bed with him, and he assaulted them. And the judge expected me to present that, to refute that evidence before it was even introduced. So the judge expected me to both, one, introduce why that the resident was being discharged, and two, refute it. And it's very bizarre, and it's wrong and illegal. And hopefully, it's something that we're going to change. We're in the process now of doing advocacy on this, and plan on either. This is something that's very, very right. Exactly, Don. Doesn't due process. Exactly. Hopefully, hopefully the people that make the decisions at DHS will realize how wrong-minded this is, and rescind or stop relying on this unpromulgated regulation. However, it is obviously an issue that we would take to litigation if that did not work. So let me go back up. There was a couple more questions. But as of now, the burden is on the resident. So you have to realize how to deal with that. And it's very hard. The ALJ said to me, well, counsel, you haven't even brought up the discharge reason. And I said, well, why would I introduce evidence against my client in order to refute it? But this ALJ is very by the book. She is not friendly to nursing home residents. My client was being discharged to a homeless shelter. They were putting him in a homeless shelter. He was incontinent. He wore diapers. And she didn't think that this was wrong. So that's what we're dealing with, unfortunately, in these hearings. So you need to be prepared for that. And this is part of the reason why I'm saying ask for in-person hearings, because you get it away from them. So Catherine asked, does this strict ALJ apply these strict rules even-handedly? In my experience, the ALJ does. However, I would say overall, how the system is based, she's much more friendly to facilities. She finds if the facility has something documented in the chart, she's going to go with that. So that's the problem. Unless you have something that can, unless you anticipate what the facility is going to say correctly and introduce the evidence, it's biased against the nursing home resident from the beginning. And she certainly doesn't make any accommodations for that resident. So that's something to be aware of. The nursing home should, I mean, they're not legally required to provide a private room to the resident for a hearing. I think you should ask, but they're not legally required. But I found if you do ask, they will provide it because they have a right to appear. And if the resident can't leave the facility, that the facility must make that. I would argue that the facility must make a room open, but there's no explicit provision. But so again, preparing now, you need to prepare in such a way that you're, and Gene Urban asked Skype, that's another way to do it. And the Skype is certainly something that we could ask for. But again, we're trying to get it out of the hands of this one ALJ in Harrisburg because she is so not sympathetic to nursing home residents. But I would, because the regulations specifically state, anticipate having hearings at the facility. And again, these regulations were written prior to Skype, but obviously we're in the 21st century now. And again, if you do have Skype, you have the opportunity for the person to be seen, your client to be seen. Pictures tell 1,000 tales. So in an issue about, oftentimes, so in my client's case, what I was talking about, with a client who was being discharged for the assault, we argued, one, ever since they started providing proper care to my client, there had been no issues. And two, it was an improper discharge. Again, so there's a two-pronged element there. So, say they're discharging them to a homeless shelter, or discharging them to a home that has too many stairs, or a home that's filthy, or a home that doesn't have water. Pictures of the discharge location is important. You could even get someone to testify at the hearing. Unfortunately for me, I had called the facility, I had called the homeless shelter, and they said to me right over the phone, oh, this happens all the time, and what we do is just call 911 and we send them to the hospital. And I said, well, will you be willing to testify to that or work with us on that? And the guy was very gung-ho. And then he must have gone and talked to somebody because he just stopped answering my calls. I think they didn't want to be depicted as a facility that wouldn't take anyone. But having someone on the line that says, no, this is in a safe place, or having that guy say, we would not be able to meet the needs of your client if he was discharged here, obviously it is very powerful and should be controlling. So let's move on. Yeah, I'm reading it. I mean, obviously, CLS, and I'm sure many of you are, we want hearsay evidence when it benefits us, but we don't want it when it doesn't benefit us. So there's certainly been situations where in my case, I tried to get it in through hearsay, and the judge scolded me, but I also objected to hearsay from the other side as well. So it's a double-edged sword. We win a lot of hearings at CLS based on hearsay objections. It's a strategic move as well. So I want to talk about some of these reasons. So if the discharge reasons and what you argue at the hearing. So if the discharge is for the client doesn't need the services anymore, you need to refute that. So you need to get like a third-party medical assessment. Oftentimes this can be done by asking the AAA to come out and do a assessment for home and community-based services. It's the same level of care requirement as the nursing home, except, so it's called Nursing Facility Clinically Eligible, NFCE. So if the allegation is that the person is no longer NFCE, have them evaluated by the AAA. The AAA can come out and do one of their assessments, and if the AAA says, oh yeah, this person's eligible for home and community-based services, you have some evidence to the contrary that the resident no longer needs those services. However, even then, I know this judge, in the face of that, has still sided with the facility, saying that that is not controlling. However, it's evidence. And remember, you have appeal rights after this, so it doesn't stay there. It doesn't stay with that judge forever, and you can ask for reconsideration to the secretary, and you're building your evidentiary record. Sometimes your resident has a doctor that they see outside in the community, and it's not affiliated with the facility. Because the problem is once a resident is in the facility, most of the time all they're seeing are facility doctors. And that facility doctor is going to do the bidding of what the nursing home wants. In my case, the facility doctor got on the phone and obviously didn't even know my client, said, oh, the client can do his ADLs and all this. And it was clear that the client couldn't. But there's an obvious conflict there between the interests of the nursing home and the interests of our client. So if there's obviously an outside doctor, oftentimes residents are taken out to specialists, even someone who's sympathetic to the client can provide, some a statement or even testify at the hearing to say, no, this client still needs skilled care. If the reason for discharge is related to the resident's health, or your defense is the discharge location is unsafe, having a third party that will testify in your client's interest is important. Again, it says attending physician from nursing home. It's very rare that an attending physician will contradict the facility. If the nursing home attending physician refuses to participate, you can subpoena them if there's information in the file that's problematic, which I think is important. If there's something in the file that 2 days ago the client was needing help with his ADLs, but they don't now, you want to be able to ask questions. Well, why is that? Why is that happening? Oftentimes the attending physician will be hostile to you as well. Again, if you can't get a doctor to testify, see if they can write a letter. Witnesses in these hearings, obviously the resident, family members, the AAA workers, the independent assessment broker workers, anyone that can provide some evidence. Family members are going to be important for say, involuntary discharges to unsafe places. If they're trying to discharge your resident home, have the husband or the wife or the mother say, I can't take care of this person in my house. There's 15 stairs. I'm 87 years old and I can't help my son climb the stairs. I had a case like that. They wanted to send him home. A 60-year-old man who had a stroke at work, they wanted to send him to live with his 87-year-old mom, who was supposed to take care of him, change his diapers and do all that. And she needed to be present at the hearing to testify, I'm 87 years old, I can barely get up the stairs myself, I can't do that. Family members aren't going to be as helpful when we're talking about medical issues. They're not medical professionals. However, they're helpful in the sense that they're there every day saying, my brother can't feed himself, I feed him, I help him dress. So that's the type of helpful testimony you can get out of family members. Obviously, questions of diagnoses or you know, more arcane medical questions aren't going to be as helpful. The AAA, if they come out and find the person to be NFC, get the AAA on your side. If you want documents, you can ask for a subpoena from the judge. It has to be 15 days prior to the hearing. So documents, if they're refusing to give you the file or any other medical records you think are helpful, you can ask for a subpoena. Rhonda asked, how do you get the doctor's letter in? Do you need a custodian of records? I would just have the doctor, I would just submit it prior to the hearing. I don't think these facilities are savvy enough to object. Maybe they would, but I would deal that, you know, if they do object, I would ask for an opportunity to provide testimony from the doctor to get over any hearsay objections. Oftentimes, sometimes these facilities are represented by attorneys. Oftentimes it's the administrators who aren't very savvy. But that's a good question. If you can't get it in, you got to try to get the doctor to testify. Okay, and these are common scenarios that I want to talk about. Non-payment. If you could show that if it hasn't been filed or is pending, you need to show why that is. Residents stuck in a nursing home, how are they supposed to get 5 years of bank records while they're in a nursing home? How are they supposed to go find out how much their life insurance policy is when they're stuck in a nursing home? So you have to explain why it's pending or why the appropriate you know, support for the application, the appropriate verification it's not because of non-compliance, it's because the resident has a hard time getting them. Or MA has been denied and appeal is filed and you're pursuing that appeal. And the only time you're really gonna find that that they might be successful is where the resident just refuses to pay. They have money and they refuse to pay, or they refuse to provide any information to help with the medical assistance application. Because for long-term care, this is all going to be Medicaid. And if they're failing to cooperate, you're going to have a hard time defending that. But again, just because they haven't been, if it's been 6 months or a year, it doesn't mean that they can discharge them. If the resident is acting in good faith and trying their best, they can't discharge them for that reason. Resident is endangering the health or safety of other residents or staff. Hold on one second, and we'll talk about, and residents' health has improved. So these are the defenses. If we already went over, well, let's go over them again. Non-payment, the law provides for transfer or discharge only when resident has not paid. Residents should not be penalized where a family member or conservator is not paying. That means that oftentimes, you know, because these people are isolated, the family members are the ones that have to get this information together. Failure for the family members to do it should not fall upon the resident, and that's a defense as well. If MA is still pending, you argue that discharge is premature because MA status is not final, and that nursing home will get paid once MA is approved. If it's denied, file an appeal and argue to BHA that it's under review and it's not final. Again, facility has an obligation under social services to assist residents with legal financial problems. Focus on what the facility has not done to address the underlying payment problem. If your client is so severely disabled and there's no one in the community to help them, what has the facility done to help that resident obtain the information to become eligible for Medicaid? So just because the payment isn't there, there are affirmative defenses to these scenarios. Rhonda just asked, how long is it taking for them to schedule the hearing? Is there an automatic preclusion once appeal is filed? Yes. So you have to, so one, it takes about a month or 2 months, I think, for them to be just, maybe less for these to be scheduled. And you want to ask for preclusion once the appeal is filed. Generally, they will do that. What they'll do is they'll issue an order stating, you know, the appeal has been filed. any discharge is precluded pending the outcome of a hearing. But I would always ask for that. I would ask specifically for the DHA to issue a preclusion order stopping the discharge until the fair hearing is conducted. And not until it's conducted, but until a decision has been issued.
Sam, if I could interrupt here, this is Kelly. I'm going to be launching the second poll for the CLE credits. You'll have 2 minutes to respond. Thank you. You're okay to go on, Sam. Thanks.
Great. Hold on 1 second. So other defenses, we'll get to the other two in a second, but other defense facility is not identified a more appropriate facility. So oftentimes you will say, they'll say, well, we don't have the resources to help this person. And one, if you're running a nursing home in Pennsylvania, you should have the resources to help anyone who is nursing home facility clinically eligible. Why are you in the nursing home business if you can't help people that need nursing home care? And what other facilities, what is in the other facility that is more appropriate? Because sometimes the facility will discharge to another facility. And if that person doesn't want to go to another facility, they have to show what is present at that other facility that's not present at the current facility. And your argument is that there isn't anything. This home is no different than the home that you want to transfer them to. And what is that other home can meet the needs that you can't? Other reasons, the facility is far away. It's 30, 40 minutes from the one that they're in. That's not fair. The resident has connections to the community. If it's another nursing home, you have to show that the need for nursing home care, again, they have to show why they can provide care that they can't. And oftentimes what this is just an effort to get rid of individuals that they can't take care of, such as individuals with dementia, individuals that are elopement risk, individuals that require additional care and in turn additional funding. But they have to show, again, why the other facility can provide the care that they can't. Lois Lara, L-O-I-S-L-A-R-A is the ALJ in Harrisburg. She really knows I don't like her. Some of this is going to get back to her, I know. Again, this is what we talked about. Under law, the facility must provide services to attain or maintain the highest practicable physical, mental, and psychosocial well-being. Why can't that facility do this? Why are they in the business of doing that? And that's the argument they need to make. We had a case once where they wanted to discharge him because the man was so obese, he couldn't get in and out of his room. That arguably violated the ADA, and they got them to widen the door. But it was an inappropriate discharge because why could another facility do it where they couldn't? Let's talk about, let me just skip ahead. Okay. So other defenses, again, in certain instances, as articulated earlier, resident's physician has not documented the need for the transfer of the discharge. Facility has failed to prepare the resident for discharge. Resident poses no danger or safety to health or others, and facility is able to meet residents' needs. These are all very hard things to do when the burden is on you. But obviously, you have to develop a strategy to be able to do that. And here are some of the strategies here. So if facility claims the resident's behavior is aggressive, disruptive, and it threatens others. So if the facility is saying that it threatens the resident's behavior is a threat to the health or safety of others, you have to really expose that for what it is. Must show what services it offered to alleviate these behavioral problems. Transfer discharge should not be on the list. My client who assaulted a person, he did so because he was on medications and he wasn't being supervised correctly. After they offered additional services to alleviate the behavioral problems, there were no other incidents for months. We should win on that alone. I didn't, even though I pointed that out to the judge. So again, but that is something the law supports. So just because an ALJ in Harrisburg says it's not, relevant, it is. Show that there are residents with similar problems. You know, oftentimes it's smoking. You know, show that other residents smoke. Show that other people, you know, smoke in undesignated areas. Injury to staff. Again, what training has been provided in dealing with these problems? I mean, residents, most of the time when it's injury to staff, it's because of behavioral issues related to cognitive impairment. And you can't hold a resident liable for that. There will be scenarios where there's violent people in a nursing home, and those will be harder to defend. But again, if you're in a nursing home and you have behavioral problems related to your disability, they need to be providing additional care. So that's how you're going to deal with those issues, is saying, one, there's other folks with these problems. Two, what have you done to address these issues? Whether or not the judge will accept them, that's a different case. So I raced through some of this. And again, it's really hard to do one of these on the web without seeing people's faces and everything. But I was just hoping, I don't know how many people do these hearings around the state, but I think it's something that we really need to get into doing more, because they're cases that you can win. One, through bad notice, improper discharge, and hopefully some of these strategies today will inform your practice on how to do it. The hearings are a problem, and CLS is currently working on that. We believe that all the hearings should be governed by the same rules that every hearing is governed by under 55 PA Code 275, and we are working on that. For now, you need to anticipate these bizarre, crazy hearings. This is my contact information. I'd love to hear from people. Yeah, we'll share a copy of the PowerPoint. I love to hear from people, and I mean it. I want to hear what's going on in other parts of the state, and I want to be supportive of your practice in these. These are cases where people get injured and people can die. They're discharging people to facilities that, you know, discharging people to places where they shouldn't be. My client, I lost that hearing. My client, the judge held that it was okay to discharge my client to a homeless shelter. So that's what we're dealing with. We're doing advocacy on that, but together, if we collaborate, I'm helpful to, I want to be helpful. We can work on these cases together. Again, I'm sorry for being so quick in some places, and I know there's a lot of questions, so you can email me or call me. Thanks, everyone.
Thank you. Everyone have a good holiday.